But since it was brought up, my only response is to say that there appears to be a fundamental misunderstanding as to the role of counsel in preparation of pleadings under the rules of the court, which were followed by India. No Indian pleading has been signed by any lawyer, unlike Pakistan's filings, and the rules of this court do not countenance filing by or through lawyers. Unlike the pleadings filed by Pakistan, India has filed pleading in its own name, signed by its agent, and takes full responsibility for the content of its pleadings. On 5th of June 2018, Pakistan wrote a letter to India demanding a confirmation that the contents of the reply are in all material respects accurate, and requesting India to confirm whether its lead counsel had reviewed or approved the reply as filed. India replied on 27 June asking Pakistan to raise any issue they desired before this court in accordance with the rules, and that, and I quote, the details of the preparation review process, including leading to the final submissions, is purely internal to the government of India. The queries raised by the government of Pakistan are therefore inappropriate and irrelevant, unquote. On 17th July 2018, the rejoinder was filed in which Pakistan pointed out the alleged mischaracterizations and misquotations. The matter should have ended there, leaving it to the court to hear submissions and deal with the expert report appropriately if necessary, since the original of the report was in any event on the record of the court. On 18th January 2019, India received from this court a letter attaching a communication of the same date received by the court from Pakistan. Paragraphs 6 and 7 of the letter raised the issue of the alleged mischaracterization and misquotation. It magnanimously offered the government of India an opportunity to consider its position, and with Pakistan's characteristic humility, which we saw on display yesterday, demanded a forthright apology and undertaking not to repeat these matters before the court. This letter raised various issues in relation to the cross-examination of Mr. J.P. Singh. A response was given to this letter on 23rd January 2019, in which, on these issues, India maintained its position. The matters arising out of these letters of 18th January 2019 and 23rd January 2019 were dealt by this court in its communication of 24th January 2019. The only order made was that the request for cross-examination of Mr. J.P. Singh was declined. Pakistan continues to raise this issue, and in my opening I pointed out the typographical error in paragraph 154D of the reply is such that it made no difference to India's conclusions. In the same part was also quoted an earlier para 19 of the reply without the error. I had hoped that this statement would put the issue to rest, but since it has not, I shall deal with it in somewhat greater detail. The other two alleged mischaracterizations of the report were competing versions of the interpretation of the report of the experts. It's a matter for submissions before the court as to what is the meaning of that report. Having had India's reply with them since 17th April 2018, and India's response to their letter of 5th June and 27th June, if Pakistan considered there was the need to get the experts to clarify the mischaracterizations, it could have done so before it filed its rejoinder on 17th July. The letter of 5th June had suggested that it wanted India's clarification as it was in the process of preparing a rejoinder. However, it did not consider it necessary to file any report or get its experts to clarify the meaning of their report. The very fact that Pakistan considered it so very necessary at this late stage to bring the experts into the box to speak to their report and clarify the alleged mischaracterization, and when this was denied, they tried to put it in a supplementary report, perhaps suggests that in their own view, the original report required to be clarified so as to leave no scope for the kind of inferences being drawn by India. The report is, in India's submission, an entirely irrelevant document to the present proceedings, since it seeks to give an expert view on matters of law, such as whether military courts are due process compliant, which, Honorable President and Honorable Judges, I submit are matters of law and matters of great moment of law to be decided by this court based on filings and submissions and on analyzing the law. That issue has been the subject of submissions on both sides. This court doesn't need the expertise of any external agencies to decide whether applying the standards of the ICCPR and other sources of such jurisprudence, a military court of that kind that is in place in Pakistan is due process compliant. This court does not need an expert to assist it in coming to the conclusion whether limited judicial review cures the defects inherent in such a system. Pakistan did not have an answer to the trenchant criticism of the International Commission of Jurists, the European Parliament, and the Human Rights Committee. It was perhaps driven to feel too gentle to give an expert, quote-unquote, view to this court on matters that arise for consideration as serious issues of human rights jurisprudence.
Burning Question, powered by Ola, New Ford Aspire, Siska LED and Vidol Engine Oil.
Pakistan sought to examine one of the two experts who had given a report to, and I quote from the letter, to provide the court with an update to the report and to address the misrepresentations of the said report by India. India opposed the request since the examination of a witness and therefore the right to cross-examine the witness required arrangements to be made in advance of the hearing, and such a request being made 30 minutes before the commencement of the opening submissions, which was first told to us, was clearly badly timed, or to borrow Pakistan's favorite expression, an attempt at an ambush. Pakistan has not offered any explanation as to why it had to wait until the morning of 18 February to make such a request. Later in the afternoon of 18 February, a second request was made for leave to display a video content on a USB drive, purportedly a confession of Jadhav recorded by someone somewhere. No explanation was given as to why this USB and the video on it were being made available for the first time on the late afternoon of 18 February, when even as per Pakistan's assertion, the video was made sometime in November 18. India opposed this request. On 18 February 2019, late in the evening, a third request was made, latching on to the clarification that the use of the word "the" was a typographical error, to file a supplementary report, a copy of which was attached to the letter. And a further request was again made that the expert may be examined at the hearing if India objects to the production and inclusion of the supplementary report. In the copy of the supplementary report that was attached to the letter and made over to India, one page was missing. India objected to the production of the report on the ground that if Pakistan wanted to clarify an alleged misrepresentation, it could have done so by filing the supplementary report along with its rejoinder. All the three requests made by Pakistan on 18 February were declined. This court on 19 February held that the request of Pakistan was made on the day of the opening of the oral proceedings, and that the production at this stage of the documents referred to as supplemental report was not justified. Similarly, in relation to Pakistan's request to produce a video, the court decided that, and I quote, "it will not be appropriate to grant Pakistan's request." In the course of its submissions, Pakistan criticized India for blocking the production of this evidence. What followed then was somewhat unusual. Counsel addressing the court said that since the production of the video was not allowed, he would orally state what was the content of the video. This is to be found in paragraph 27 of the transcript of the hearing. Something which was declined to be taken on record was sought to be placed on record, or the substance of it was sought to be placed on record, using the opportunity to make submissions. Again, there is a reference to a video relating to meeting of Jadhav and his wife and mother. This is not on record. Counsel deposed as to its contents, which is in para 75 of the transcript. The production of the supplementary report of the experts was declined, but counsel took upon himself to inform the court what was in that supplementary report. If a request for additional evidence is declined, to accuse the other party of blocking that evidence unfairly is clearly a criticism of the order of the court. Worse is an attempt to place on record through oral submissions the content of evidence, the production of which stands declined by the court. And finally, I was surprised to hear a mention of some money lying in Jadhav's account or deposited in Jadhav's account and how the money reached there. Our team has, in the time available since yesterday, searched the entire material and not found the mention of rupees 90,605, the figure from the transcript, deposited in his accounts by way of pay. This was a statement made in the course of submissions. We checked, it is not in his confession. It is not in the available on the material we checked yesterday. If it is on record, I'd be happy to stand corrected.